Chicago Urban League. I am excited today to welcome Esther Franco-Payne to the stage of the EJC. Many of you know that the EJC is the Equity Justice Compact that the Chicago Urban League started with the R's group. It is an effort to ensure equity in the implementation of the cannabis legalization process in the state of Illinois. And we know that part and parcel of that effort, in addition to the economic development, is the opportunity for expungement. We're going to hear all about that with our special guest today. Esther Franco-Payne is the executive director of Cabrini Green Legal Aid. She is a longtime advocate in the criminal justice and all around equity and justice arena. She has worked hard relative to expungement, but even before that prospect, she has worked hard for equity and justice in the community, particularly in the Chicagoland area. She is an alumna of the University of Chicago School of Social Service Administration. She has served on a variety of boards and commissions that have been focused on and directed towards justice and bringing a more just and equitable community. One of those is Cook County Board President Tony Preckwinkle's Intervention and Prevention Research Advisory Council. And so I'm going to stop talking about Esther and let her talk to you about the important work that she does. And then after that, we'll have a conversation about that work and her efforts. Welcome, Esther.
Thank you so much, Karen. I'm so excited to be here today. I see some familiar friends who are joining us and who are also brothers and sisters in that fight with me. So it's good to see people joining this conversation today. It is an ongoing conversation. Equity and justice is a journey, and one that we must continue to join forces in order to achieve our final destination. So I'm really excited to be having this conversation with you today, and I certainly appreciate the invitation. So with that, we'll just get started. And Cam, if you can pull up our PowerPoint in the slide view, please.
Sorry, give me a second. It's a PDF, so.
Oh, sorry about that. Okay, well, we'll just keep it moving. So just to tell you a little bit about Cabrini Green Legal Aid, we were founded in 1973 as a ministry of LaSalle Street Church in the Cabrini Green community. Our founder was at the time a pastor, Bill Leslie, who said to one of the volunteers, Chuck Holgren, that there were many community residents who needed support around legal services due to engagements with law enforcement and a range of other matters. And so he told Chuck Holgren at the time that if I find some money, will you start helping people? Chuck Holgren said yes, and that is how Cabrini Green Legal Aid Clinic was born. And so our duty at that time was to support residents of the Cabrini Green Housing Project, But today we serve a wide variety of clients across the city of Chicago, Cook County, and the state of Illinois. So I just always like to, talk about from where we were founded to where we are today. In 2014, the organization made a strategic decision to support only those with criminal backgrounds. So our mission reads that we are here to seek God's justice and mercy for those living in poverty by providing legal services that strengthen individual lives, families, and communities, and that we always want to have people leave us stronger than they came. But as we made that strategic decision, we had to think about the services that we were providing. Next slide. Thanks, Cam. So that really focuses, again, only on people who have been impacted by the criminal justice system, whether by arrest and/or incarceration. So we have about 50 to 60, I think, legal aids throughout the state of Illinois, but we are the only legal aid that exclusively focuses our supports on that population. So any and every case that comes to us has to start from that point. We provide defense services, and that is helping clients when they are faced with the case, and we support them through the court case. We provide criminal records relief, which includes your sealings, your expungements, your clemencies, your alternative forms of police relief. We provide civil legal services focused on family law and housing law. So in the case if your rights are threatened because you are going into the carceral system and/or you are threatened with losing your housing or being denied housing due to your criminal background, we will support you on that. We also have an emerging adults practice, which focuses on our young people or people with juvenile records. And so we want to make sure that in order to break the cycle of crime and violence, that we are supporting our young people so that they are not faced with impediments as they travel throughout their journey. And then all of our work is supported by a team of social workers through our client support services. So we recognize that while people might have a criminal background and they might receive criminal records relief, that does not mean that you are stable. That does not mean that, your full life is where you want it to be. So you can have your record cleared and still be faced with housing instability. You can have your record cleared and still have family disconnectedness. So we try to make sure that we are addressing every part of a person's life where they feel the need, and we try to make sure that we are helping clients to accomplish their goals. Next slide, Cam. All of this is so that we are supporting clients to overcome the barriers as it relates to the collateral consequences of being justice involved. There are over 49,000 laws, policies, and regulations across the United States that tell people what they can and cannot do as a result of the arrest and/or incarceration. Nearly 9 in 10 employers use background checks in hiring. An estimated 4 in 5 landlords use background checks on prospective tenants. And 3 in 5 colleges and universities use background checks in admissions. So at CGLA, our goal is to remove those barriers by providing criminal records relief and creating access to justice so that people have the opportunities for employment, housing, education, etc. All of these circles here demonstrate areas where people have been impacted by their criminal records. You're told you can't vote. You are denied public benefits in some cases. Again, housing is such a big issue, one of the biggest issues our clients come to us with. So we want to make sure that we are alleviating the collateral consequences. Next slide. Within that, there are 4 million people in the state of Illinois who are touched by the criminal justice system. That is just Illinois. That means that either someone has been arrested, they are on supervision, they are sitting in jail and or detention and prison, and or they are on parole or probation. And so we know that we can't serve 4 million people through our small shop at Cabrini Green Legal Aid. So our focus is to really change the system. Thus, we get involved in policy and advocacy work to change laws and legislation to ensure that we are providing and opening the doors to people who might not use our services, but again, need that relief. And we've been successful in changing several laws within the state of Illinois that have to do with barriers to employment, education, housing, and otherwise. So we're very proud of that. And our overall aim, you had it right, Cam, is to give justice a voice. That is our tag, right? Many people are disenfranchised. Many people don't have access to policy and decision makers. And so it is the goal of CGLA that we stand alongside and walk with our clients and our community to bring voice to justice. Next slide. Now, one of the things that CGLA has been engaged in is the implementation of the social equity components of the Cannabis Act, specifically as it relates to the expungement components. And so that is what I am here to speak with you about today. But the social equity components of the Cannabis Act is really a three-legged stool, right? To ensure that social equity applicants have access to the industry, to ensure that there is expungement of minor cannabis convictions, and to ensure that there is community investment as a result of the profits that are being made within the cannabis industry. Next slide. So the Cannabis Regulation and Tax Act allows for the legalization of adult use cannabis, recreational use. It allows for commercial sale, production, home cultivation, creates the social equity components, and allows for minor cannabis convictions to be expunged. Next slide. However, when people first heard that the Cannabis Act was passing, some of us thought this was a free-for-all, but there are certainly still many limits and rules that are being imposed. So we always want to make sure that while people understand that while recreational use is allowed, that they understand what that looks like. And so here you'll see that, Illinois residents may possess up to 30 grams. Anything over that, if you are in contact with law enforcement, you can be arrested. 5 grams of cannabis concentrate and up to 500 milligrams of THC in an infused product. Anything over those limits can, create some tensions there where you are either ticketed or arrested. So we always want to make sure that people understand this, because the passage of the act does not mean that you can do anything that you want. There are still regulations. And then you'll see non-residents within Illinois and what those limitations are. Next slide. Unlawful persons to possess cannabis in the following locations include on the school bus, anywhere near a school or corrections facility, any private residence that is being used for social services or childcare. And if you are carrying cannabis within your vehicle, it must be in a sealed, child-proof, child-resistant, odor-proof container. So we want to make sure that people understand this as well. Similar to alcohol, you cannot have open bottles in your car and things like that. The same kinds of rules apply in this space as it relates to cannabis. Next slide. Besides a car, of course, any public place. So you cannot be walking down the street, smoking openly, or utilizing products openly. And there are even regulations about being on your front porch where, it can be smelled or, seen openly. So again, even though that is your private home, if one of your neighbors were to contact law enforcement, you could be arrested because that is considered the public way. Qualified patients and caregivers under the compassionate use of medical cannabis, which is guided by a whole other set of rules and regulations, are exempt from many of these possession and use limitations. So if you are a person that has a medical cannabis card, there are a different set of rules and regulations that one must understand. That is not our lane, so I can't go into the details of that, but you would want to know what those regulations are versus the regulations and rules for use around recreational use. Okay. So what I just went over was really focused on state limitations, but certainly each city and township has their own limitations. And so here you will see that these are related to the city of Chicago and the ordinances that they have put in place. So there are penalties for violations, including fines in the amount of $50 or more for the first offense, and then $100 for subsequent offenses. So the goal within the city of Chicago, if you violate any of the things that I read off before, is that they will try not to arrest you, but instead institute fines and fees in relation to the violation. However, I think following 3 infractions, you could be faced with arrest. That is not on here, but it is an important point. So people should be aware of that. People under 21 years of age who come in contact with law enforcement may have other requirements. Again, we are trying to prevent arrest. So these might include, performing community service, attending drug awareness programs, or restorative justice programming. The goal is to keep as many people out of the system as possible. So a group of advocates worked hand in hand with the city of Chicago to come up with alternatives to arrest. However, if there are several infractions, you could be arrested, and or if you are violating the limitations in terms of the amounts. So that is to be noted. And then, violations in terms of your car and vehicle, you could have your vehicle impounded. So that is something that the city is working on, violations for cannabis possession and consumption removed from the city's vehicle impoundment program, meaning they are working to not impound your car, your vehicle, but you could have your vehicle impounded. So it is best to stay safe in regard to making sure that you follow these rules and regulations. Next slide. So CGLA, we are not here to focus on recreational use. We want people to know and understand what is associated with recreational use so that they are not coming into contact with the system. That is our primary goal, to keep people out of the criminal justice system and to make sure that they can overcome barriers when they are in the criminal justice system. So our primary focus in this space is to provide criminal records relief and support impacted populations so that there is access to the industry. And this is a very important component because as we talk about social equity in this space, we want to make sure that anybody, regardless of your record, can have access to business ownership and or employment. And so we are here as your community lawyer to assist you in clearing your record so that you can either be employed in the industry and or assume business ownership in the industry. Next slide. Some of the career pathways in the industry include these different areas: craft grow, cultivation, infusing, processing, transporting, and dispensing, right? And we know that the state is going through a whole ordeal right now as it relates to licenses for dispensing organizations. But however that shakes out, our goal again is to make sure that people's records are cleared so that they can choose any of these career pathways without any issues. Right now, community colleges are offering student careers and cannabis certification, which qualifies them to work with, study, and grow live cannabis plants and provide instruction on best practices, professional responsibility, and legal compliance of the cannabis industry. So I know that one of our City College partners are on the Zoom call today, and it would be fitting for anyone who is interested to get in contact with City Colleges, Olive Harvey being the premier college right now that is focusing on this industry and providing education and opportunity through these career pathways. Next slide. So owning a business or working in the industry, you have to be licensed. All employees and agents have to be licensed by either the Department of Agriculture or the Department of Financial and Professional Regulation, IDFPR. And that is where CGLA kind of comes in. Next slide. So as an agent, you are considered a principal officer, board member, employee, or other agent of all cannabis producing business types who is 21 years of age or older. Everyone has to have an agent identification, particularly those who come in contact with the actual plant. And so there are often times when people have a hard time accessing their agent identification card due to their criminal backgrounds. That does not mean that you are prohibited from working in the space. So let's go to the next slide. A fingerprint-based background check is required, but again, felony or misdemeanor convictions are not automatically disqualifying. So, you know, there are certain things that IDOA and IDFPR cannot consider, which are listed here: your juvenile adjudications, arrests that didn't result in charges, dismissed cases, or convictions or arrests that might have been sealed. But, you know, organizations and government are run by people. So sometimes there are subjective factors that come into play and people can be denied, but there are other factors that might consider an outright denial. And so people have the right to a hearing so that IDOA and IDFPR will consider those other mitigating factors and evidence of rehabilitation. Right? And that is where CGLA comes in, because we will represent individuals at those hearings and help you to present those mitigating factors. Next slide. So examples of mitigating factors might be the length of time since conviction. So you can go before the board and say, hey, my conviction was 10 years ago. I believe I should not be denied, right? And so here you'll see 5 years since last conviction, 3 years since prison release. And if you have a clean record since then, we can present that as mitigating evidence. Age at the time of criminal offense. If you were 17 at the age of your last conviction or infraction, and you're now 32, right? We can present that as a mitigating factor. I should not be denied opportunity because my offense was X number of years ago. I was, you know, a young person, made a mistake, I'm here now to clear that up, right? Whether your sentence was completed satisfactorily, sometimes your record might, not be read in the right way. And so oftentimes when people are reading a criminal background, which is a whole different training, they might not understand how the actual offense was completed, right? Whether you satisfactorily completed your supervision or what the final disposition is and or was. So those are things that we can look up in the system, see that, present that as a mitigating factor. Of course, fitness and professional character. This is where you are able to get recommendations, whether it be from other employers, your educational institution, your church, family and community members. We want to present information that shows that you are doing well and that there are people in the community that support you. So that definitely adds to the mitigation in terms of, showing the whole picture. And then other certificates of good conduct or certificates of relief from disability. This is a state issued alternative form of relief that sort of demonstrates the fact that you have overcome your engagement in criminal behavior. So those are the things that we would use to provide mitigation in support of you being able to access your agent identification card. Okay, next slide. So oftentimes, people don't quite understand what they have access to in regard to criminal records relief and whether or not their actual offense is able to be overcome through criminal records relief. So again, those two primary factors include expungement and or sealing, right? And then you have the alternative forms of relief, those certificates that I just named. You have healthcare worker waivers, you have clemencies, right? Pardons. Those are all different kinds of criminal records relief. But the primary two are expungements and sealings. So, next slide. How a criminal record is created, right? The first point of contact is an arrest. You can be arrested by your city or village police department. You can be arrested by the Illinois State Police or the FBI, right? And so there, the RWOC, sorry for the acronyms, is release without charge. And oftentimes people do not know that they have a record if they were released without a charge. And that makes up a majority of criminal records. A good chunk of criminal records are just mere arrest. We call them mere arrests. People don't oftentimes know until they are filling out a job application and the background check comes back, right? So I got arrested for, making noise in the public way or whatever, when I was 18. You have an arrest. The police might have let you go, but that arrest will show up on your background. So it is important to know the circumstances under which you have come into contact with law enforcement and what remedies are available to you to get those records cleared. And we'll talk a little bit more about that later. But dispositions, that occur, a complaint can be filed, you can go to court, you can be charged in court. So once you go to court or have any engagement with the court system, that too solidifies your record. So then you have an arrest record in the law enforcement database, and now you also have a court record to accompany that. Next slide. Here you'll see, types of criminal offenses. So this just tells you the difference between misdemeanors versus felonies. So I won't get into all of that, but, these are the different types of offenses. Next slide. So let's talk about expungement and sailing. So records that can be expunged or are eligible for expungement are non-convictions and pardon convictions, right? Records that can be sealed are eligible convictions. And people really think that because they have a felony record, that their record cannot be sealed. However, and I'll talk about that a little later on, we were able to expand sealing in 2017. And so before the change of legislation, only 9 convictions were eligible for sealing. But after the bill passed and was signed into law, it expanded sealing. So now only 4 types of records are prohibited from being sealed. So there is access to sealing. You can even seal a murder conviction. You can even seal a violent crime, which is a misnomer in the community where people are not aware that they can seal those types of offenses. Now, again, you have to present good mitigation, and it is at the discretion of the judge, but there is access to sealing. So I want everyone to know that you can have your record sealed. Okay, so expungement, next slide, is where records are erased from law enforcement or impounded in the courts, meaning they are put away. No one, including law enforcement and courts, should be able to access these records. They should be gone completely. With some exceptions, only charges that do not lead to a conviction can be expunged. So you have to keep that in mind. That is the majority of your mere arrests, right? But certainly your misdemeanors. And then sealing, next slide, is when records are hidden from the public view. So only law enforcement and certain organizations that are authorized through statute can see these records, okay? Expungement is a complete clearing of records. Sealing is hidden from the public view. With some exceptions, convictions can only be sealed. Remember what I said earlier. So state's attorneys can see the record, the FBI can see the record, law enforcement can see the record, armed forces can see the record. There are authorized organizations by statute that can see your record. Public education institutions. So we have to recognize the difference. That is an important difference. If an arrest comes up on your record that has been expunged, that is incorrect. So you would have to show an employer or whatever institution where you're trying to have access evidence of your expungement, which you would receive following that expungement. Okay, but sealing, there are opportunities for authorized organizations to see that record. Next slide. So as I talked about, only 4 offenses are prohibited from being sealed. This is domestic battery, violations of orders of protection and stalking, violations of the Human Care for Animals Act, so animal abuse, sex crimes, except prostitution and misdemeanor public indecency, those can be sealed. But the majority of sex crimes cannot be sealed. And then DUIs, driving under the influence, and reckless driving, except for youthful offenders. So here you'll see the statute number. But these are the only things that cannot be sealed. Okay, next slide. So the difference again is access. No private or public entity should be able to see and expunge records, right? No private or public entity should be able to see a sealed misdemeanor conviction. Only eligible organizations that are named within the statute, right? But all sealed records are available to law enforcement. And then sealed felony convictions are available only to employers authorized by law. So again, regulated by statute, and this is where the fingerprint-based backgrounds would come in. Okay. So next slide, clearing your record under the Cannabist Act, right? The Cannabis Regulation and Tax Act. So when the act first passed, next slide, it was named through data research that over 770,000 records were eligible for relief under the Cannabis Act. That totaled to almost 550 individuals, because we have to recognize that some people have several infractions on their record. So the records themselves are counted by individual charges, but it totaled up to about 547,000 individuals across the state of Illinois who would be eligible under this act. Next slide. There are 3 pathways to relief under the Cannabis Act. You have automatic expungement for non-convictions less than 30 grams. You have automatic pardons for cannabis convictions less than 30 grams. And this is where the governor has made those pardons. And then you have motions to vacate and expunge less than 30 grams, if not handled by the pardons process, and or between 30 and 500 grams, possession only, those convictions are eligible. This is where you would self-petition, and or the state's attorney can handle the motion to vacate and expunge on your behalf. So as we know, our Cook County State's attorney here in our jurisdiction has been moving cannabis convictions automatically without the need for a person to self-petition. But every jurisdiction is not like that. We have 102 jurisdictions within the state of Illinois with 102 different state's attorneys who have the ability or not to move those records. Okay, so here you'll see who does what. Next slide, sorry. Automatic expungement is done by the Illinois State Police and the arresting agency. The pardons are done by the Illinois Prisoner Review Board, and then the governor signs off on that. And then the motions to vacate are done either by an individual on their own behalf or the state's attorney. Okay. In the act, there were certain deadlines as to which the automatic expungement bucket would be completed. So here you'll see where the records were created and then the deadlines by which they were to be expunged. Now, the great thing is that our state has already moved some of these records, and I'll get to that in a moment. Next slide. A minor cannabis offense, when we are talking about, well, what kind of offense will be defined under this act, has to do with possession, manufacturing, delivery, possession with intent to deliver, which is known as dealing. Again, 30 grams or less. No penalty enhancements, meaning nothing else could have been added to that charge, and does not count those cases where there was a violent crime listed on your record, even if that crime was dismissed. Okay, so these are the criteria for which the state reviewed the eligible records up against these criteria as named in the law. Next slide. So again, here you'll see a minor cannabis non-conviction, automatic expungement by the Illinois State Police and or your arresting agencies. Minor cannabis convictions with those offenses that I just named would be pardoned by the Prisoner Review Board. Cannabis possession, manufacture, deliver, possession, all of those would go through the motion to vacate from 30 to 500 grams. minor cannabis pending, meaning if you were charged before the act, but your record, if you were charged before the act was implemented and then the act got passed, but your charge had not gone through the full court process, then there was to be filed a motion to dismiss and expunge. And a defense attorney can do that on your behalf. And if there was anyone who was serving a prison sentence at the time for any of the eligible offenses, there was an immediate order for release. So those last two things have already kind of been taken care of because the act is already now more than a year old. Okay, next slide. So here, when we were talking about the deadlines and the numbers of expungements that were eligible, over 501,000 records were already moved through the automatic expungement process. This includes the expungements and the pardons that the governor issued last year in, I think, January 1, 2020. So 501,000 records. They've met all of the deadlines by moving these records through, which was almost a miracle, but such a great step in the right direction. However, these are, again, arrest records only. And I know that when Danielle Perry had come to speak with the group, she did explain how this process moved forward. But for a majority of these records, there are likely as many court records remaining. And remember, I did show the two pathways. So we have arrest records that can be released without charge. Those are the records that were cleared. But if your record went to court and you now have a court record, those records still remain in the court and need to be expunged as well. So there's a lot of work for the state and the locals to do in terms of clearing out those court records. This is a very difficult situation because a person might have received notice that their record was cleared through this automatic process. But if you go for a job at Target, that court record will still pop up. So it will still show that your record is there. So we are working very hard as advocates, working with the government system stakeholders and others to make sure that those records get cleared from the court system as well, and that that burden does not lie on the individual. If the state said, we are here to move these records automatically, we want to make sure that the full record is cleared. So here's a summary. I won't go through that. Just want to touch on a few other items because the point that I am making, next slide, about having your full record cleared is an important one. So for CGLA, we are moving towards a clean slate agenda because we do feel that there are opportunities for the state to be responsible for the clearing of records. The Cannabis Act serves as a good test case and proof of concept for how this can be done. But again, it takes all actors within the criminal justice system to join forces to get this done. And we want to make sure that, again, the burden does not rest on the individuals. So next slide. Here you'll see just some trends about why this is important, right? The number of petitions statewide have gone up. They were up, right, in 2017, but now they are falling. So it means that people are not accessing relief as much as they can for those records that are eligible, either by way of people not having the awareness that they can have their records cleared, or being, being afraid of engaging with the system. We hear that all the time. I met a person in Champaign County who was 70 years old with a 40-year-old record, right? It was fear. So people are not filing for relief on their own behalf as much as they were even before the passage of expanded sealing. So we want to make sure that people are accessing relief. But again, if they are not, we have to think about what remedies we can put in place to ensure that people access records relief. Okay, next slide. So of course, there's a relief gap. We call it the relief gap. 90% of people who are eligible for records relief have not pursued relief on their own. That's the problem. Next. Within Cook County, CGLA works very closely with our court actors here in Cook County. And what used to be a 6 to 9 month process to get your record cleared has only been amplified. 1, by the number of petitions, but 2, by COVID, by the pandemic. The courts were closed for 6 months, and while petitions were being added to the system, they were not being moved on. So there are 3,000 plus records sitting in a county backlog, and this number is as of December 31st, 2020. So there could be more at this point, but they are sitting in a backlog in Cook County, meaning it is taking some time for those records to move through the system, almost 21 months at this point. Next slide. So you'll see here that there are petitions with no objections. That's where the state's attorney does not object. That 1,182 can certainly be moved through automatic expungement, right? If we had those qualifying offenses. So that's where we want to do the most work so that people don't have to wait 21 months, so that people don't have to act on their own behalf. We want to make sure that people can access criminal records relief. If I am applying for a job today, and I say, okay, I'm going to take the step to get my record cleared, 21 months from now, I'm in a bad position because that employer says, no, you can't have this job, and I'm still waiting for my record to be cleared. So that is something that we are working on very intently. Next slide. Through our clean slate principles, we want to make sure that punishment ends when system involvement ends. We want to make sure and give the message to our system stakeholders that automatic record clearance is good government, right? We should not be making money on the backs of poor people. We should not be putting the burden on the individual. Automatic record clearance is good government. For good government for everybody. We save time, we save money, we save effort. Removing the barriers caused by a criminal record closes racial and economic equity gaps. Again, in talking about the fight for equity, this is all about equity, right? People who have access and privilege can get their records clear easily. They have access to attorneys, access to finances to support them, etc. We want to close that gap. And then records relief should be associated with meaningful reentry and restoration of rights and not considered a reward, right? That is extremely important. So we are working with different stakeholders to ensure that we can move a clean slate agenda. We've been in touch with Representative Justin Slaughter, Representative Jahan Gordon Booth, to talk about what the possibility of a clean slate agenda would look like. Okay, so just know that while you all don't always see us, there are advocates in the community who are working on your behalf. Next slide. Available resources. Next slide. If you are seeking records relief, particularly for your cannabis conviction, please access the New Leaf Illinois website. They will do an intake for you and direct you towards the right legal aid with an immediate slot so that you can have access to a lawyer and free representation. If that doesn't work, you can certainly just call CGLA. We are always here. Next slide. So here's the information for New Leaf. Next slide. Here's the information for CGLA. I will definitely share that with Karen so that that information can be emailed out. And again, don't sit. We want to make sure you have what you need when you need it. We are here to help you. It just takes that first step. The first step is contacting someone who can support you. Hopefully, if you have had a minor arrest or a minor cannabis conviction, you are already in that automatic pool, but you can also access legal aid services to remove that court record. You can check if that court record still resides in the system. And so again, we are here to help you. This is all about public awareness. This is all about making sure that people have access to the information that they need. So thank you.
Esther, thank you for such great information. Thank you for your advocacy, and the Chicago Urban League is really proud to partner with you on the local criminal justice project that we're doing with the city. You know, you raise a good point relative to what the Cook County State's Attorney is doing versus the other state's attorneys and the huge gap that exists. So I think there's maybe an opportunity for the entire network of urban leagues throughout the state to work with you. So we'll talk about that offline. But one of the things that I'm interested in is for you to talk about what happens once folks have the opportunity and realize the opportunity for expungement. So if their records are expunged, if their records are sealed, are you finding that people are able to gain access to either employment or other participation in the industry?
Well, in the industry, we are keeping tabs on that now. And what I can say to you, Karen, is that we have found a couple of instances where people have been denied employment due to their backgrounds and or the misread of their backgrounds. So they should not be denied employment based on a mere arrest, for example, whether it's expunged or not, right? The state law asks you to, well, we've been pushing for ban the box, and you know that ban the box exists within different spaces around the state. But when you check that box, it's about a conviction. Right. So if you pull my background and you see an arrest and you deny me employment, that is not right. And so people have to access their due process in order to fight against that. So what I'm saying is that we have found where people have been denied employment due to mere arrest on their records. And so we are pulling together a couple of case studies to cite this issue. And I have been working with some of the cannabis companies to talk about this issue out loud. I want to know, how many people of color are you employing? How many people with backgrounds are you employing? What are your hiring practices, and how can we advocate for and enforce equitable hiring practices? So those are, I would say, fairly new conversations. We have been in a partnership with Olive Harvey and the community colleges. And so we're helping some of the students that are coming directly from the certification program with their backgrounds as they are accessing employment in the industry. And for a few of those students, we have found this issue arise as well. And so once that happens, you have a whole issue with your agent identification card. You know, there are lots of different factors going on in the background. And so we want to pull this information together so that we can make it known and have these hard conversations with our cannabis partners. I'm also very interested, ready and waiting for what the impact study will demonstrate once that is completed at the state level, because I think that can be also a very useful advocacy tool in this discussion. The numbers won't lie.
I
Unless
think that's
people lie.
important, at both in and out of the cannabis industry, because employers generally should understand what expungement means. And so much is about education, understanding, arrest versus conviction versus expungement versus sealing. So I think that there's an opportunity for education across spectrums in employment. I'm going
Absolutely.
to turn this over to Cameron Hughes so that she can field some questions from the audience. The information that you've given is just priceless. So thank you so much. Cameron.
Thank you.
Hi, everyone. So if anyone has some questions for Esther, I know we're close to time, but Esther is open to answering any non-specific legal questions from anyone in the audience. So if you guys can send it in the chat, I'll make sure that we get your questions answered.
And if we can't answer them today due to time, just send them along and we could send back written answers for sure. Not opposed to doing that at all.
And we'll certainly pass them on, Esther.
I see Orlando's raising his hand.
You see one?
I'm going to unmute you so you can ask your question.
Nah, I'm sorry. I was trying to use the chat box, but it says that the chat's disabled. The question I had was, what is the level of education that's being provided for people pre-release? Because this is information that I think would serve those that are going to be coming home and having that knowledge prior to their release so that they can engage in this process, because not only is the misinformation and miseducation out here, it's definitely very minimized and even censored while people are incarcerated.
Yes, thank you for that question, Orlando. So CGLA does have a partnership with the Illinois Department of Corrections. We provide Know Your Rights education and education around family law so that people will understand their parental rights, because that is one of the number one, it's high on the list of issues that people face once they are returning home. So due to the pandemic, we have not been allowed into the department, of course, right? Due to safety reasons and what have you. And so I just had a conversation, particularly on the women's facility side, but this will translate for the whole department in regards to how we can provide written information and send down pamphlets and things like that, and also maybe create opportunities for virtual discussions and pre-recorded training material that we can send to the department so that those things are easily accessible to our individuals who are incarcerated. So that is something that we are working on. Pre-pandemic, we were in the Department of Corrections doing that community education at least 1 to 2 times a month. But, it's been over a year with the pandemic, and the Cannabis Act became fully implementable January 1 of 2020. So you can see that how that might have limited us in being able to provide just this education. We do have a body of individuals who work alongside of us called the Leadership Council. And those are individuals who they were either former clients or community members who are impacted individuals who want to get engaged in the advocacy. So they help us with our legislative agenda. They provide know your rights education. They are front and center in the community. And so we oftentimes also have that information travel through them. So they've been doing some online or virtual know your rights education, whether that be at community events, churches, wherever we are asked to be, we try to be there. And those stories come personally from people who have been engaged with the system, but can deliver this content, with firsthand knowledge about how it worked for them. So we're very proud to be working with them and to have them engaged in our work. And the goal is just to be as vast and wide-ranging as possible, particularly in a time where this pandemic is preventing people from being face-to-face in the ways in which we normally would be.
Thank you so much, Esther, and thank you, Cameron. Cameron, do you have one last question you want to put? I know we're at time, but we're going to squeeze it in.
We have a question from attorney Liz Holmesy. They want to know, are there resources available for clients seeking expungement or sealing who need a TSC drop as part of their petition?
So Task is an organization. Yeah, they do the drug drops. So yes, and right now, because it has been difficult for people to access drug testing or, for whatever reason due to the pandemic, to access fingerprinting, please contact us at CGLA. We have some partners also who are willing to sponsor the fees associated with that. So we are trying to find all the ways in which people can be supported and not let the barriers to getting your fingerprints or your drug drops inhibit you from moving forward with your criminal records relief. So just please contact us and we will work with that client.
We've got to ask this last question because it's so important. Cameron, would you ask it from Joyce?
Joyce wants to know, is it possible to create an online expungement summit so that people can go through the process online?
Great question, Joyce. Thank you. We do that. So on an annual basis, CGLA has worked with the county clerk, former clerk Dorothy Brown, for the last 15 years to host the annual Expungement Summit. Hundreds and hundreds, almost 1,000 people annually come to this one-day event. And so the first thing I want everybody to know is that criminal records relief is accessible 365 days a year. You do not have to wait for the annual summit. Just call us, call New Leaf, and we will support you. That is the first thing. The second thing is that given the pandemic, last year was the first time that we tested a virtual summit. So we did do that. We were able to support close to 400 individuals, over 600 participated. And we did that online. And so in the onboarding of our new county clerk, we are working with her and her new staff to figure out how to do an online summit for this year. But I would say don't wait, because you don't have to get your record relief in that one day. We want you to access it each and every day it's available. So we are here for you. But that is something that we are doing and trying to refine. All of our services right now are virtual. So if you go to the CGLA website, press Get Help, you download your documents, and you are good to go.
So with that, we are going to close out what has been an incredibly informative session. Thank you for the work that you are doing on behalf of the community, Esther, you and your colleagues at CGLA, and colleagues all over the community who are engaged, not just in expungement, but in removing all of the barriers that exist to active participation in a just society. And we look forward to working with you through the EJC and through the Urban League network throughout the state. Thanks to everyone who has participated on behalf of the EJC, on behalf of the Chicago Urban League and ours. And please stay tuned to our next convening, because we promise that we will continue to fight on behalf of equity and justice in the cannabis, quite frankly, in and out of the cannabis arena. Thank you. And thanks, Cameron,
so much, Karen,
for everything that you're doing to advance this cause as well.
Yes, thanks, Cam. Enjoy
Have
your
a great day,
everyone.
everyone.